Hello friends, in the series on the income tax cases, today we will discuss the case of Venkateswara Rao versus Assistant Director of Income Tax. This case has been reported in 106 ITR Tribunal at page number 531. The matter has been decided by Hyderabad ITAT B bench and the date of the judgment is 10th April 2023. This case is very interesting and this case is a perfect example that how our income tax authorities behave in a careless manner. In this case, the case of the assessee was opened under section 143 subsection 3 on the limited issue of cash deposits. This case was related to the assessment year 2017-18. Detailed inquiry was done with the assessee and the assessee submitted all the documents relating to the cash deposits. But somehow it was by mistake or maybe any other reason, the assessing officer did not pass the assessment order within the period of limitation of passing the assessment order. When the assessing officer realized this thing, that the assessing officer has not passed the assessment order, he immediately issued notice to the assessee under section 148. As all we know, when the notice under section 148 is issued, the assessee has to file its return of income. In the old regime, the assessee filed its return of income. The notice under section 143 subsection 2 was issued after that. And when the reasons were supplied to the assessee, in that reasons, when the assessee got to know that the case of the assessee has been reopened on the same issue of cash deposits, the assessee vehemently opposed the reasons for reopening the case by saying that the same issue was involved in section 143 subsection 3 notice, so the assessee cannot be issued the notice under section 148 on the same issue. It is like change of opinion. But it was the submission of the assessing officer that since the assessment was not completed, so the assessing officer has every right to go for the proceedings under section 147 read with 148. And the assessing officer made the addition under section 69A for the cash deposits in spite of the various submissions made by the assessee. When the assessee moved to the CIT appeal as usual in maximum number of the cases or in majority of the cases upheld the order of the assessing officer. Now there is a great feeling that CIT appeal is not an appellate authority. It is a part of the income tax department. So it is very painful for the assessee. The assessee moved to the ITAT and the ITAT said that in this case, when the notice under section 143 subsection 3 was issued to the assessee and the assessment proceedings were going on, then it was the duty of the assessing officer to pass the assessment order whether in favor of the assessee or whether against the assessee. But it cannot happen that you start the proceedings and you do not conclude the proceedings. The ITAT held that it is not allowed to the assessing officer to reopen the matter again on the same issue which was part of the assessment proceedings under section 143 subsection 3, especially when the assessee has submitted all the details. It is like that if the assessing officer has missed one bus, then he can catch the another bus. Because if this situation will be allowed to the assessing authorities, then there will be no use of the limitation period. And the ITAT held that the assessment done by the assessing officer under section 147 without passing the order under section 143 subsection 3 on the same issue is not justified and it is void ab initio and bad in law. Friends, on the same issue, there was one case decided by some other court. In that case, the court said that the assessing officer has the power to open the assessment under section 148 in this case because there is no prohibition in section 148 for doing so. Because if the department has reason to believe, then the department can do. But with due regard to that court, in this case, the ITAT has given a very justified and very balanced decision in favor of the assessee, that if you have missed the bus of section 143 subsection 3 after issuing the notice and you have not completed the assessment by passing the order, then you cannot issue the notice under section 148 and complete the assessment on the same issue. At the end of this video, once again, I am repeating the name of the case. The name of the case is Venkateswara Rao versus Assistant Director of Income Tax. And this case has been reported in 106 ITR Tribunal at page number 531. The matter has been decided by Hyderabad ITAT B bench and the date of the judgment is 10th April 2023.